Good afternoon and welcome to another edition of Law is Stranger Than Fiction. I'm one of your co-hosts, Steven Bergman.
And I'm your other co-host, Barry Shoal, and we are shareholders at the law firm of Richards, Brant, Miller, Nelson.
And today's episode takes us back into the realm of trademark law, where there's another battle brewing over the use of what would seem to be a common word. Barry?
Yes, indeed, there is a battle brewing over the term outsider. Utah-based apparel company Cool has obtained a trademark in the term outsider for certain apparel items. It has sued industry giant LL Bean for its advertising campaign, Be an Outsider.
And let me stop you for a second. So Cool obtained a trademark on the word outsider.
Yes, for particular items of apparel.
Okay, so they don't have a general right to the word outsider. They have it to, for example, describing one of their products.
But for a line of outdoor wear, yes.
Okay.
So Cool is suing LL Bean for trademark infringement, notwithstanding the fact that LL Bean doesn't carry products manufactured by Cool in its stores.
And they're suing them for using the word outsider.
Yes.
Even though they're not, are they describing any of their own products as outsider products?
I believe this is more of a general campaign encouraging consumers to be an outsider by attiring themselves in outdoor wear from LL Bean. Cool is claiming that they might suffer financial damage if consumers are confused about the source of the products based on the outsider campaign.
So Cool is claiming that because LL Bean is promoting the use of its outdoor wear by saying be an outsider, that people will be confused as to where to buy Cool's outsider brand of products.
And that Cool owns all rights in the term outsider with regard to outdoor apparel.
But now, has LL Bean actually used the word outsider to describe any of their products?
Only, I believe, in its in-store displays.
Okay, so in other words, wear this and go outside type of thing. Wear this so you can be an outsider. But they're not saying, for example, buy LL Bean's outsider pants or outsider shirts or anything like that.
Correct.
Okay. And when was this lawsuit filed?
In October of last year.
And does this lawsuit have anything to do with the fact that LL Bean is planning to open its first store in the state of Utah?
Well, one wonders, only because the inaugural LL Bean store will be located right down the street from Cool's flagship store in Park City.
Okay. Does Cool have any kind of history of aggressively protecting its trademarks?
As a matter of fact, yes. It sued Yeager over the use of an advertising campaign that urged its consumers to have a cool spot. Cool, as you might know, is German for the word cool or neat. So Cool, the clothing manufacturer, is claiming that there may be consumer confusion resulting from Yeager's advertising campaign as well.
Okay. And it's my understanding in trademark law, and I know you do a lot more trademark law than I do, that you have to be aggressive in protecting your trademarks or trade names. Otherwise, you're at risk of losing them. Is that right?
That's correct.
So one could say that, in this instance, Cool is simply protecting its rights by being so aggressive, couldn't they?
One could say that.
Okay. Well, that's it for today's story. As I mentioned, that Barry is an expert in trademark and copyright law. If you have any issues concerning those areas, please contact Barry. Or if you have a litigation matter concerning trademarks or copyrights, please contact me. And for now, this is another edition of Law is Stranger Than Fiction.